to CRA 00456. Counselor, good morning.
Good morning, Your Honor. Rachel Smith, standing in for Carlos Johnson, who is listening on behalf of Ms. Taylor.
Thank you very much. All right, in this particular case, the charge is a felony of the second degree, I believe. A felony of the second degree puts you in a position to face up to 8 years in prison, a minimum of 2 years, and a $15,000 fine. They are alleging that on or about July 7th in the city of East Cleveland, Ms. Taylor did knowingly cause or attempt to cause physical harm to a Ms. Kuntz by shooting her in the shoulder and thereby causing the lung to collapse. Counsel, on behalf of your client, how are we proceeding in regards to the preliminary hearing?
Your Honor, we would waive all rules on the preliminary hearing.
All right. So, Ms. Taylor, what that means is the case is going to be sent to the county, and as I mentioned, we're going to set that court date for you, which will be Monday, 12th floor of the Justice Center at 9:45. Madam Prosecutor, it looks like the bond request is $100,000 surety, correct?
Yes, and I had a conversation with Detective Stanford this morning. They are kind of adamant about that bond in light of the level of her injury and the fact that she's still in the hospital fighting for her life.
Okay. Counsel, I would like to give you an opportunity to be heard.
Thank you, Your Honor. Your Honor, Ms. Taylor is 28 years old, has completed school through the 12th grade and was working towards her GED at the time of the birth. She is currently not employed, but is a homemaker. She's married and takes care of her 2-year-old daughter, and her wife works as a traveling nurse. Ms. Taylor has no criminal history. She's here by way of self-surrender, and there is no reason to believe that Ms. Taylor will not continue to appear.
Okay.
She's eager to face these allegations.
Thank you. All right, so Ms. Taylor, and if we have any other felonies, one thing I didn't mention that's important is that the bond that I set is your bond basically from now until Monday. Once you get down to the county can adjust your bond up or down depending upon other facts that they find out. They can even give you a personal bond, but I always do set a bond from here to there. Based on the alleged injuries that there may be a collapsed lung, I'm going to leave the bond at the $100,000, but I will make it 10% surety, so which makes it a little bit easier for you to get out. Keep in mind, though, Ms. Taylor, if you're not able to do that, the bond will likely be reduced based on your counsel's arguments on Monday, okay? But other than that, good luck. Counsel, go ahead.
Can you respond to the condition of the victim being a consideration of the bond? The Ohio Supreme Court in January of this year clarified under DuBose v. McGuffey that the paramount consideration when setting monetary bail for a defendant is whether or not they will appear to face the charges against them. Other concerns, which are valid concerns, like the seriousness of the allegation, as well as the condition that the alleged incident left the victim in, the court stated could be addressed through reasonable measures such as GPS monitoring or house arrest.
Okay, and I absolutely agree with that, and it's interesting, counsel, that you bring that up because once I did hear about that that ruling, it troubled me. I mean, dearly that the Supreme Court would even make that decision, but it's their prerogative to do that. I think it may apply, in my opinion, until they specifically state municipal courts, maybe to the judge in the county that will have the case from beginning to end, because that judge has those other means that they can do, whether it's GPS or other ways to make sure that she continues to appear for that trial or the pre-trials. Here, with it being at least a first appearance going down to the county, I'm going to accept your argument, and I know that there are ways that you can handle that if you need to, and I appreciate that, but I will leave the bond at the $100,000, 10%. All right? Thank you, though. Appreciate it. Ms. Taylor, good luck. My emotions could allow me to not say how troubled I was with that decision. This was like these Republicans up there. They actually said that. They have actually said that bonds now, you cannot even be concerned about anybody's injuries, anybody's safety. Just they will come back to court. That's yes, man. It's you know why? Because they don't live in neighborhoods like we do. They're down in Columbus. They come from all over the place. They have no clue of the danger that happens in our hood. So interesting. Michelle Lockett, 22 TRD 01700. Miss Lockett, July 2nd. They're alleging that you were driving with an expired plate and sunscreen violation. Just so you know, the sunscreen in Ohio is supposed to be 50% of the light coming through. Anything less than that, they can give you a citation. They marked yes for insurance, and it looks like what the city was going to do is dismiss the plate charge, and you would enter a plea of no contest to the tint. Is that correct? How do you plead? All right. And normally what the tint charge carries is a $150 fine, but I've been reducing those down to $25 plus cost. So just go to the clerk's office, $25 plus cost, no points. Be blessed. You're welcome. Danielle Ratcliffe. (22 TRD 714, driving without, well, it says failing to control your vehicle, and then maybe weaving within the lanes. But what the city has done is amended the charge to unsafe motor vehicle, which carries no points, and she's agreed to dismiss the second charge. Is that your understanding? All right. To that amended charge, how do you plead? All right. So it carries no points. The moving violations is a $200 fine plus cost. You've shown insurance, but the good thing is we can give you time to pay if you need that, okay?
How much is it?
It's $200 plus cost. That's the fine. But then time to pay, you just need to bring in at least $25.
Today, but I just need to know how much.
You just need what, I'm sorry?
I'm here to pay today, but she said 200.
Yes, $200 plus cost.
What's that cost?
The court cost, they'll tell you at the clerk's office the exact total.
Okay.
Okay. Have a good day. Imani King L. 21 TRD 03532, driving under suspension and a speeding. The driving under suspension has been amended to failing to display your license. That keeps you from getting any points. You don't get suspended. And I'm able to lower your fine from that minimum. Remember I mentioned driving under suspension carries $500 to $1,000, but I'm able to cut that in half based on what you've accomplished with getting your license back. So you want to handle it that way? So to the amended charge of failing to display, how do you plead?
No contest.
All right, so I'll accept the plea as opposed to $500. I'm cutting it in half and dismissing the second charge. You're not going to have any points. And once the clerk's office do the calculations, if you need time to pay a balance or if you have money coming back to you, they'll let you know, okay? All right, you take care. Dominique Campbell. 19 TRD 02408, driving under suspension and a sunscreen, as well as 21 TRD 03493, driving under suspension and sunscreen. So it looks like the city is going to dismiss the the new case in its entirety. Is that your understanding?
Yes.
All right. And then to that old case, you were actually going to plead to the amended charge of failing to display your license as well as the sunscreen, correct? How do you plead?
No contest.
All right, so I'll give you the lower fine on failing to display, which is $250 as opposed to the higher fine. And I'm going to reduce the $150 of the sunscreen to $25. So you go to the clerk's office, they'll do the calculation from there, and be blessed, all right? Take care. Justin Hooks. 21 TRD 03617, driving under suspension and a sunscreen. The driving under suspension is being amended to no driver's license, which means you're working toward getting your license together. So the city wants to give you the break of the lesser charge and the lower fine. Is that your understanding? And the tint's going to be dismissed. How do you plead to that charge? All right, so I'll accept the plea with the fine of guilt as opposed to $500. I'm going to cut it in half. It's $250 plus costs, and you just go to the clerk's office. Take care. Lydia Jackson. 22 TRD 01156, a stop sign violation that's being amended to unsafe motor vehicle so that you don't get any points. Is that how you want to handle it?
Yes, sir.
All right, to the amended charge, how do you plead? Okay, I'll accept that plea. No points are associated with it. It's a $200 fine for the moving violation plus cost, but the good thing about handling it here is you're able to get the payment plan if you need that, okay? All right, you just go to the clerk's office. Take care. Teresa King.
We hold off on her.
All right. Miss Morris, is it Kaylanta? Palanteo. 20 TRD 03930, driving under suspension and a sunscreen violation. The city has agreed to amend the charge so that you get the lesser fine and no points, and dismiss the second charge. Is that your understanding? All right. To the amended charge of failing to display your license, how do you plead? All right, I'll accept that plea with a fine of guilt. As opposed to 500, we cut it in half for you. And if you need time to pay, go to the clerk's office, okay? Mm-hmm. So what happens with your bond is that'll be applied. So you may only owe a little bit after that. So we can give you time to pay that extra amount. And so it doesn't disappear on you. All right, you take care. Devontae Smith. Mr. Smith, we're here on the domestic violence charge in 22 CRB 00401 and 22 CRB 00400, and we're going to set both of those for trial, maintaining not guilty, correct? Mr. Smith, keep in mind there is that no contact order. Do you have a reason to go back to the home now? Okay, because I believe there was a whisper to the court that you may have gone back home for a while or went back to talk to your mom or something like that. Make sure you don't do that, because how old are you? 21. These issues of domestic violence, whatever happened, you're maintaining not guilty. We can work that out. There's no doubt we can work that out. Monday, I had to send somebody to jail for 6 months for violating the order, not even the domestic violence, because I'm trusting you that when I let you out, there's not going to be any violence. You understand what I mean? So we're going to set this for August 18th. And Mr. Smith, I'm just saying it because it's on my mind, the no contact order is so extremely important to me because of my concern for your safety and everyone else's, because we live in this community, right? So, the assertion that bonds and things shouldn't matter, they matter because it's about safety. It's not about money. It's about just making sure everybody's safe. So, all right. August 18th at 1:30 is when you're going to come back, and I'll see you there. Hey, Mo. Good morning. Good morning. Did you know it was coming? I just don't like her, man. There's certain things that I don't like care for this, man. We'll get it there, you know what I'm saying? But man, we have to show people, man. We live in this community, man. We see this. We've been seeing this all our lives. We've been seeing nonsense all our lives. Looks like somebody got to take the message. Can't believe she forced me on the record with that. No, she did. She forced my hand. All right, Dominique Bell. 22 CRA 00471. Good morning, sir. The charge is having a weapon while under disability. It's alleging that on or about July 13th in the city of East Cleveland, you did have ready at hand in your apartment a gun with a specific serial number. It was a 9mm with live ammunition in the chamber. There's a previous conviction that would cause you or create the disability or inability to have a gun. That's what weapons under disability is, based on your previous conviction. It's being charged as a felony of the 3rd degree. That means you face the possibility of 9 to 36 months in prison and a $10,000 fine. You spoke with the defense attorney, Ms. Conwell, correct? Yes, sir. Ms. Conwell, on behalf of Mr. Bell, how are we proceeding?
On behalf of Mr. Bell, Your Honor, emphasizing the rights of the minor and struggle with his rights.
All right. So what that means, Mr. Bell, as I mentioned, I'm going to set a court date for you, which will be Monday, 12th floor of the Justice Center at 9:45. You're still not guilty. I'm going to hear from the city on their request for bond, and then I'll hear back from the attorney. Detective?
Yes, sir. Your Honor, you have Mr. Bell in front of you, pleading guilty to 2 sexual arrests, domestic violence, misdemeanor conviction. we want to have 25,000, security. But if you wish to give them 10%, I have no problem with it.
All right.
Also, could you, put on the docket that, he needs to see a mental health judge also?
All right. Sir, have you spoken with anybody about a bond that you can post? Is anybody able to help you out right now?
I ain't reached the phone yet.
Okay. So we'll note that, and the detective will help you out in that regard.
He got numbers in his phone, but he couldn't bring it upstairs.
Okay. All right. Counsel?
Yeah, if I may, I just want to ask for the 10% since the detective stated they would have no issue with it.
Okay. All right, so yeah, what I'll do is I'm gonna set it at 20,000, 10%. So I'm gonna lower it a little bit. Detective, I don't know if I'm looking here. I don't see any other circumstances, extenuating circumstances that would make me keep it higher. So if you don't mind, I will do that.
It's all right for that, Your Honor. He has a real big problem. Mental health judge needs to address this.
Okay.
And he's taking medication and everything.
All right.
He was off his meds at the time, drinking alcohol.
Okay.
Certain things happen in his life, and it's still coming into his head and everything about his sister being killed
Okay.
at an early age and everything. So he really needs some help from the courts downtown.
Okay.
And to see if we can push this away from him. Like I told you, he just got to deal with it. Everybody that left him, they was just a shell that he was in. Everything else is in his heart.
Okay. Officer?
I know Officer Reese Cleveland. I was there at night. He's a good guy. I'm really concerned about himself, and he put the officers and the citizens of East Cleveland at risk when he don't take his meds.
Okay. All right. So we're going to definitely make that noted for the mental health docket. And Mr. Bell, how old are you?
32.
32. Very rarely do I have two officers stepping up, not to speak badly, but to speak for you. You know what I mean? So, let's get in the position where we can use whatever resources are available. So the next 32, 60 years of your life, you're not dealing with these issues. You know what I mean? All right. You had a question?
I also thank you to both of them.
Okay. All right. Absolutely.
I'm coming from Stanley Lewis. So
Okay.
I want y'all to see where I'm coming from. That's
Yeah, so you have a legacy, but you can make it work. That old case that you were dealing with and whatever you're dealing with now, it'll be part of your testimony. It'll be a part of your example to other people how they can come back from that. All right. So keep that in mind.
I ain't gonna hesitate.
All right. So we're gonna make note of that too. You need them now. All right. And what'll happen too? We're gonna make sure that transfer happens as soon as possible. All right. You can have a seat.
Signature health.
Signature Health.
Yes.
All right.
I'm Amanda Price.
All right. Thank you. You can have a seat. Get you have a docket? You got a docket in front? Let me see it. Oh, is it pre-trial? Yeah. Larry Walker, 22 CRA 00461. Any trials? Sure. I think we got a DVD last all night. All right, this is alleging that on October 10th, there was a receiving of stolen property, a felony of the 4th degree, 6 to 18 months and a $5,000 fine, because they're saying that you were in possession of a registration that was reported as stolen out of Cleveland. So it looks like a vehicle registration. And then there's failing to comply with officer's order, felony of the 3rd degree, 9 and 36 months and a $10,000 fine, because they're saying that you were fleeing from police officers in a residential area at speeds of approximately 70 miles per hour, causing a substantial risk of harm to yourself and others. You spoke with the defense attorney, correct? Counsel, on behalf of Mr. Walker.
On behalf of Mr. Walker, Your Honor, after speaking with him in regards to his rights to exercise his rights to preliminary hearing, he's chosen to waive those rights.
Okay. So, Mr. Walker, the court date will be Monday, 12th floor of the Justice Center at 9:45. And as I mentioned, we're going to hear from the detective on the bond. And any bond I set can be reset downtown and likely will. Detective.
Your Honor, Mr. Walker's 21 years of age, no cycle arrest record at this time. His speed was a great deal to the factor into the city, and he crashed this brand new car into a pole and everything. And I believe they had to chase him down to get it. The vehicle is not listed to no one. Kia said that they would have to find out what lot he got the car off of. But for that, Your Honor, we'd like to have $100,000 surety.
All right. So again, Mr. Walker, the bond I set will be your bond from here to the county and adjustable there.
Judge, if I may.
Yes, please.
I'm just asking for a reduction. Maybe instead of a surety bond, 10%, maybe like half that, 50,000.
So what I normally do with the bonds in regard to the fleeing and eluding, it starts at a $50,000 bond. $50,000 goes up from there based on, several factors involving speed or if there was an injury or anything like that. Doesn't look like you hurt anybody. Look like you could have hurt yourself. You may have crashed the vehicle, Mr. Walker. So what I'm going to do for my part, I'm only seeing you for this brief moment because the case belongs to another judge. But at 21 years old and no record, try to make some better decisions in regard to how you deal with police officers, because the high-speed chases often end in some type of violence, death, or other tragedy. I mean, you know what we're dealing with, or everyone was dealing with in Akron.
He had a weapon, Your Honor. Can we put on record that we'd like to have the record forfeited, Judge?
So then there was a weapon involved. The detective is saying that they're going to ask the courts to grant them the forfeiture of that, but that'll be handled downtown. Yeah, so Mr. Walker, I'm gonna go ahead and I'm gonna reduce your bond because, I don't know. I don't know what sometimes I try to just, especially at your young age, I try different strategies as to what I can do as a judge, maybe showing you that this legal system, I mean, they're asking for 100. I'm willing to cut it all the way in half just to give you an inkling of the fact that if you try to deal with the legal system, and it's not going to always work out, but sometimes it can. So what I mean by that, yeah, stopping for police, sometimes there's an unknown there, depending upon if I have a weapon, if I was selling drugs, if I got in a fight. But it's a lot better than running, because that is a tragedy waiting to happen, whether you end up dead, hurt, or hurting somebody else. Because like I always say, when you woke up that morning, no matter what you were doing at age 21, you didn't wake up and say, later on tonight, I'm going to get in my car, I'm going to drive 70 miles per hour, and I'm going to kill an old lady walking across the street. But that can happen. So with that being said, though, I am going to reduce the bond just to give you a chance to see that the legal system can work for you. I'm not sure how it's going to work out downtown, but I wish you good luck. It'll be 50,000, 10% or surety as opposed to 100,000. All right. And your court date is Monday. You can have a seat. 22 CRB, detective. That's your last one.
I believe so, sir.
22 CRB 00460, Shadymon Henderson. This is a charge of assault. Assault is a first-degree misdemeanor, which means you could get up to a $1,000 fine and 6 months in jail. Initially, you were charged with throwing a rock through the car window of a Miss Holder's vehicle. The rock may have struck the lady in the face, causing an injury. So, to be honest with you, how long have you been in jail? How long since you come up to me? How many days? 5? Just so you know, just based on what I read, that's normally a felonious assault charge, 2 to 8 years in prison, because there's an allegation that some type of weapon, the rock becomes a weapon, was used and it hurt someone. So the city, first of all, charged you with assault, which is a lesser charge. And then it looks like the city prosecutor has some more information. Go ahead, Ms. Prosecutor.
Yes, I spoke with Ms. Holder yesterday. She is present in the courtroom today. She signed a refusal to assist form. And the form matches basically what she told me, that she thought this incident kind of got blown out of proportion. She felt it was more of a criminal damaging incident rather than an assault. She was more trying to cause damage to the car, but the window did break, but she said that she basically had a superficial scratch. It wasn't as major as the initial report sounded, and she didn't want to pursue this matter any further. So in light of the minor nature of the incident, I reduced it to a minor misdemeanor disorder.
So that gives you the opportunity to have this all the way down to a minor misdemeanor, which means you would not have the criminal case on your record. Do you understand that? And Ms. Holder is in the courtroom?
Yeah.
All right, and that's your desire? All right. All right, so to minor misdemeanor, how do you plead? Is it no contest? All right, because the no contest is not disputing the facts, but not saying the words "I'm guilty," so I can accept that. It'll be a finding of guilt for the minor misdemeanor. It'll be a $150 fine plus cost, but you'll have time to pay that, and I'll have you released from jail today. Just get on a payment plan so that you don't lose your license. And whatever was going on that caused you two to get into a dispute. Ms. Holder, how old are you? Okay, and how old are you? 21? All right. 20. So all I want to say is that Ms. Holder and the prosecutor are being examples of compassion, because like I said, it could have been a felonious assault. So I don't know what your relationship is, but I would say, I'm not saying you got to be best friends or anything like that, but keep in mind that, those two parties worked together to keep you from having something on your record. That's a big deal, because going forward, you don't have to worry about this, but you got to make sure you don't make the same mistake. All right. Control your anger, control your emotions. Don't get caught up in this legal system. And you'll be released from jail today. Are you working?
Not apparently.
Okay. Ms. Black?
Your Honor, Deborah Black, domestic violence for the record, Your Honor. Your Honor, I had a long conversation with Ms. Holder, and we really have two young people who are really on their own. Her family's not in the picture at all, and her family's not supportive. And they have a lot of trying to deal with. It took a while for me to get her to be forthright. She's actually volunteered to start coming to our group, and I've already told her I'm going to discuss this with her, because I didn't know what she would do, to see what we can do about getting her, because that's all it takes.
Okay.
To learn some coping skills, and she's willing to do it. Hopefully she'll be willing to do the same.
Absolutely. Because the two of you are going to remain friends, right?
Right.
All right. So yeah, it's going to be nothing but building skills and making sure that the two of you get along in a way that doesn't cause the legal system to be involved. We don't need to be involved with your friendship, you know what I mean? But when you start arguing and acting out, that's what's going to happen. So definitely work with Ms. Black, okay? All right. You can have a seat. Teresa King. Take care, sir. You had a question? We lowered it to 50. Yeah, I lowered it from 100 to 50. Hopefully that'll help a little bit. If not, Monday they'll reset that for you. All right. Isn't it interesting?
Ms. Taylor, I don't have hers right now. I'll get it down there to you.
Thank you.
All right. Teresa King. Ms. King. 22 TRD 01541. The charge was disobeying a traffic control device on June 23rd. And it looks like the city is making sure that the charge becomes a non-point violation. It's a muffler charge?
Correct.
Okay. So the muffler charge doesn't carry any points. You have insurance. And with the fine that I impose, if you need time to pay that, we can work with you. Is that how you want to resolve the case?
I'm just gonna pay for the tickets, Your Honor.
Okay. So how do you plead to the amended charge of unsafe motor vehicle?
No contest.
I'm sorry.
Loud.
Well, loud muffler, I'm sorry. No contest? I'll accept the plea. As opposed to a $200 fine, we'll cut it in half. It'll be $100 plus costs, and you just go to the clerk's office. All right. All right, take care. We have another case. Ms. McCullough, can you look at this? This is another one of those plea in abstentias, but I didn't want to do it. They have a traffic and the obstruction, so I wait to get your approval on how you want to handle that. They want to do a long distance plea, which normally means we would dismiss the criminal offense unless you didn't want to. All right. Sir, you have a case? Okay. All right. So it looks like we're adjourned for this morning. I don't know. He has a private attorney. You have a private attorney?
I spoke with her. He called her. She called. We spoke this morning. I want to get a little more information from the alleged victim in this matter, and she asked that if we could reset it for next Thursday.
Oh, no problem at all. All right, so we're going to reset that based on the prosecutor's conversation with your lawyer. And that will be the 21st of July at 9:30. We'll give you a reminder. And thank you for being present. A lot of people don't show up when their attorneys don't show up, and that's not the right thing to do, so thank you. You have a reminder for him? July 21st at 9:30. And then other than that, we are adjourned until this afternoon.
We got any trials?
You don't think so? For a change, no trials this afternoon. And I just need the file. All right, what's up, everyone? Court is over. What's that? I didn't. What's the latest?
I was telling them, I said I was never so all done. I'm a Democratic executive committee person.
Take care.
And it looks like we're not gonna have any black senators from Northeast Ohio.
Oh, really?
No black state senators.
Who's running?
The only one for our district is Barnes. Well, you guys are the same Senate district that I'm in, not in the House district, but the Senate. So Barnes, but he didn't get the endorsement. Kent Smith got it.
Oh, yeah, Kent's
I
been.
know, Kent was, he really did y'all wrong out here. But I told him to expect that when I ran for state rep. You remember? Because I was knocking, out knocking on doors. You
Yeah,
remember that?
yeah.
I told him, I said, he's not gonna do anything for these people. And he didn't.
Yeah, it's interesting.
So he
Take
just
care,
got-
man.
they
Thank
just
you.
gave him that endorsement for Senate out here. And Barnes called me and I said, go ahead, put your sign out there. Because I didn't make the meeting. I had stuff scheduled. They waited till the 11th hour to schedule it and I couldn't get there. But I'm glad I did because I've been thoroughly disgusted.
Yeah. What you gonna do? What you gonna do?
Then they got Glenville merged with Parma.
As far as what, the district?
It's Tennessee, yeah.
Yeah. They're-
So
they're
that's
really
messed
right
up
there.
too.
Yeah.
I know. I said, wow, that's deep. That's messed
We
up.
gotta stay involved as much as we can, because you're right, they're taking over and doing whatever they want, so it's
Oh, heck
interesting.
yeah. Like, that means us not having any voice at all.
Right.
She was trying to tell me to shut up, and I'm like, nah, I don't think so, because I'm just thoroughly outraged.